by lawyers. In the United States, the landmark case of Brown v. Board, Brown versus Board of Education, it did more than merely strike down segregated schooling. It actually altered the moral compass of a whole society. In Brown v. Board, equality, the concept of equality, moved from parchment to playground. That litigation, crafted with patience and intellectual precision, told a divided nation that constitutional equality cannot coexist with systematic humiliation. In India, our very own Keshavananda Bharati did something equally extraordinary. It declared that even a sovereign parliament cannot destroy the basic structure. Even, in other words, even a constitutional amendment can be declared unconstitutional. That one-line doctrine, born of argument, scholarship, courage, ensured that democracy in India can virtually never be hostage to transient majorities. Those cases remind us that the law, when guided by principle, becomes an instrument of social transformation and not merely one of dispute resolution. India's own freedom struggle offers several compelling testimonies to the nation-building power of lawyers, which is part of the main theme today. Mahatma Gandhi was trained in law. His method of satyagraha was at its core a moral argument framed in legal consciousness. Gandhi turned courtroom ethic into a mass moral movement. Nehru brought to politics the analytical discipline of the bar. Ambedkar, one of our most formidable legal minds and founding fathers, converted centuries of social exclusion into constitutional guarantees of equality and liberty. He converted suffering into structure and injustice into institutional reform. The Sardar Vallabhbhai Patel, before he unfurled and united the princely states, was a barrister whose courtroom discipline shaped his administrative decisiveness. These were not men or persons who abandoned the law for leadership. They expanded law into leadership. And even in independent India, young lawyers have risen not merely to prominence, but to transformative influence. Law does not whisper, friends, from dusty volumes. It thunders through the ages. Law remembers, leadership imagines, and nation building requires both. There are a lot of examples of lawyers who have successfully leveraged their courtroom acumen into legislative and ministerial leadership, shaping significant national policy. That must always remind us that the courtroom is indeed the rehearsal space for national leadership. Consider then Maneka Gandhi's case, where constitutional advocacy expanded Article 21, the right to life article, into a charter of at least procedural due process. That judgment did not merely protect the passport holder involved. It infused Indian constitutionalism with the idea that the procedure must, externally judged, be just, fair and reasonable. A single case widened the moral horizon of liberty. Maneka taught us that procedure without fairness is power without legitimacy. Similarly, the global dismantling of apartheid was shaped not only by political agitation, but by the legal training of persons like Mandela, who understood that the courtroom and the constitution could become theatres of resistance. Mandela proved that even a prisoner trained in law, as he was, could cross-examine an